rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument in case number CV22 0678, Murray v. Murray. These proceedings are being video and audio recorded and live streamed, so we ask counsel to please state your name and identify your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to preserve some time, if you'd like, for rebuttal. Also, please keep in mind that we have read the briefs and have conferenced the case this morning. And with that, counsel, you may proceed.
May it please the Court. My name is Marlene Parntrelli, and I represent the appellant Andrew Murray, and with me here is my colleague Alexandra Crandall. We're here today on a very simple issue. Should the trial court have granted a hearing on husband's Rule 85 motion for relief from judgment? We believe that it should have. Contrary to the framing of the issue by wife, this is not an issue of whether the family court should have set aside the decree. That is not an issue for this court to decide today. In fact, the family court did not have enough information to make a determination as to whether or not the decree should be set aside. And that's part of the problem, because there was no basis to determine from the pleadings the credibility of the evidence that was presented.
Can I ask you a question? Is every time somebody has a substance abuse problem, that makes it impossible for them to enter a consent decree?
Absolutely not. That's not the criteria.
Did you allege that he was under the influence when he signed, or he had a substance abuse problem?
It's a little bit of both. We alleged that he had a substance abuse problem. Wife acknowledges, in fact, in her petition that she files with the court, at the very first petition, electronic record number 1, that he has suffered from long-term drug and alcohol abuse addiction issues.
There's no doubt about that, because the consent decree anticipates that he's going to have to take drug testing.
Correct.
So everybody understands that he has a drug issue. My question then is very specific. Did you allege that he was under the influence at the time he entered into the consent decree?
We alleged that he was incapacitated at the time that he entered into it, and in fact shortly thereafter went into rehab as a result of his addiction issues. And
could you just, if you have a site, if you just give me the site, I'd appreciate it, where you allege that.
I'm going to go back to our motion for relief from judgment, which was ER 20, and it indicates that he was in a vulnerable state, that she had knowledge of his vulnerable state, and that consisted of that misconduct on her part.
Counsel,
because she was aware of that vulnerable state.
Vulnerable state is different than being incapacitated. Wouldn't you agree?
Yes, I would, Your Honor, but you don't need incapacitation under Rule 85 to have somebody's misrepresentation, fraud, or misconduct.
Help me understand better, because there's a difference between your client being incapacitated due to substance abuse at the time he put pen to paper in a 24-page notarized document versus misconduct by the other party.
And the only thing that's required under Rule 85 is the misconduct, fraud, or misrepresentation
and
by
I guess
the other
what
party.
I'm asking you is what your claim was, and what's your best case for the proposition that a Rule 85 motion has to be followed by an evidentiary hearing, even when the party filing it doesn't timely request one?
Well, they did timely request it because within that 6 months that you're able to bring that motion for relief.
Help me when you first requested an evidentiary hearing.
When we brought the Rule 85 motion asking for that motion for relief from judgment, but we asked for it actually twice, because in the record we asked for it with respect to the motion for relief for judgment. It provides those facts that indicate that the court...
Just to clarify, your 85 motion was filed in August.
Correct.
And in the last paragraph, it talks about an evidentiary hearing, but there's no separate request for an evidentiary hearing. And then in December, you file a formal request for an evidentiary hearing. Is that fair?
That's fair, but I don't think we have to actually provide a request for an evidentiary hearing in a motion for relief. If the court sees that the family court sees that there are facts that are stated in the motion for relief from judgment that would indicate that there's been, under two separate sections of Rule 85, either misconduct, misrepresentation, or fraud on the part of the party, or...
And that would be wife, not your client.
That's right, that they find that there has been, that's what has been alleged, is that there was this misconduct on her part.
But you don't get an evidentiary hearing if you just say misconduct, fraud. You have to allege facts.
And we do that, Your Honor. We allege that he was suffering from this addiction. He didn't actually have the capacity to be able to enter.
You didn't say that. That's not what you said. You said he was vulnerable. There's a big difference between saying he's vulnerable and he's incapacitated.
But, Your Honor, we also, though, indicate that he was going into rehab. And that's why, if there's conflicting evidence, and there is conflicting evidence.
Hold on. Let's take it one step at a time. I may have a substance abuse problem. I may be going into rehab. But right now, as I said at this bench, I am not incapacitated. I'm not admitting that I have a substance abuse problem. But I'm just saying.
I had no comment on that.
I know. I can see you writing a judicial conduct complaint as we speak. No, but that's my point. Just because someone has an addiction does not mean they're incapacitated. So you would have to allege to the court he was incapacitated at the time he entered into the consent decree.
I don't believe that's necessarily the case, Your Honor. It's because it could have been all of those events leading up to it, which are alleged in the motion for relief and are identified in the opening brief as well, is that wife knew during this period of time that he has substance abuse problems.
And that's undisputed.
And that's undisputed. And during that period of time, she files a petition asking for, the basic things, child support, maybe I get spousal support, confirm each party.
13 months before the consent decree,
And
right?
exactly.
Is that...
Because she's negotiating with him. He doesn't make a single appearance in this case until the consent decree. He doesn't respond to the petition. They could have taken his default. They didn't do that. Instead, what we have is wife and her counsel continually making motions to continue this on the dismissal calendar, continue it. Because behind the scenes, what's alleged in the petition is wife is putting high-pressure tactics on husband. She's negotiating with him. She's telling him things. She's working it out on the sidelines with him. He then says in his motion for relief, and then what I'm presented with, what I realize now in hindsight, is I was signing something that was completely different than what I actually thought we were negotiating and signing. And those are factual now contradictions that exist in the record because wife now files a response to that and says, well, I didn't know at that particular day, exactly your argument, I didn't know on that particular day that he was incapacitated and he signed it. But it's everything leading up to it. It doesn't
Counsel, let me ask
necessarily
you a hypothetical, just to kind of step back one from the facts of this case. If a party signing a document is not incapacitated on the day that they sign it, but has been perhaps continuously for months leading up to that day, are you saying that that means the contract is not enforceable?
It could be, and in fact, the responding brief even indicates...
It's a hypothetical.
And hypothetically, it could be, because depending on what the misrepresentations, the fraud was, and the misconduct that existed ahead of time...
You're kind of altering the hypo. I sit down, I'm asked to sign a contract, day 1, month 6. And I've been on a bender for 5 months before that. But that day, I'm fine. Plenty of time to look at the document. It's a notarized document, comprehensive, tons of exhibits. I sit down and I sign it. You're saying that that is not enforceable?
If your hypo, though, assumes a couple of facts. One is that there was a document that had been negotiated and that you had time to sit down there, read it, you understood what you were doing, and that you signed it there and did it. None of those facts are in the record. In fact, those
Is
are
there
the
an
facts.
allegation that he didn't have an opportunity to read this? I don't remember that from IR20 from your motion.
But what there is in the record is,
Just so we're clear, that's not contained in IR20, right?
I don't believe so
Okay.
in those exact words.
Well, I'm happy to have you point me to where that concept is alleged in the motion.
Well, the concept of what has transpired throughout the entire 13 months.
My question, though, was on the day.
Right. Well, he indicates that he wasn't aware of what he was signing or doing and that he felt that he was incapacitated. Does
Where
he
is
come
that?
out and say specifically
I
that?
thought we'd established that he didn't say incapacitated, he said vulnerable.
Well, he says vulnerable, and he also says that, and I want to just read it specifically so that I don't misstate it, but he specifically indicates that given the severity of his substance abuse and wife's knowledge of his substance abuse, he feels that and again, there's a injustice here that occurs not just under 3, and I do want to make sure I'm not forgetting that there's also B6 here, because the court was supposed to act as a gatekeeper with respect to, is this a fair and reasonable document in the first place? And so we also, are proceeding on those grounds as well.
And the parties have vowed that it was in the document itself, correct?
I'm sorry, Your Honor, what was
The
the question?
consent decree says that it's fair and reasonable, right?
It does,
Yeah.
but if the consent decree is written by wife and it is contrary to the things that they had been negotiating previously, it's a different document than what he had thought he was going to be signing.
Did he actually allege that? That
He
she
did-
presented him with a different document than what he, and if so, could you read me to that part of the,
Yeah,
the-
it says, wife actively took advantage of husband's diminished capacity. She used high-pressure tactics to induce husband to sign documents presented to him. Moreover, even though the parties engaged in successful negotiations to craft a document, wife ultimately provided husband with a significantly one-sided agreement that was of her own creation and which husband believes does not represent a fair and equitable division of the out. She pounced.
does he say that he didn't understand the document, or that he doesn't understand that it's different than what he thought they had negotiated?
He says wife pounced on his low point and utilized his lack of capacity and lack of representation to place an inequitable document before the court. As such, wife's misconduct warrants it. That's with respect to B3. So he does allege those facts, that I was not able, lacked the capacity at that point in time. She knew that I lacked that capacity. She puts before me this now one-sided agreement that I thought we were talking about a different agreement during these 13 months. I sign it. It gets presented to the court. And I do want to go back to Your Honor's question about, but it says that it's fair. That's a boilerplate line that is put into every consent
Understand.
decree written by wife.
Written by any attorney counsel. I mean, that's not a shocker that it would contain that.
It's not, but the reason we put it there is the court is supposed to then make that finding. The court had no basis to make that finding. These parties had never been before the court before.
Oh, counsel, you can't possibly say that the court has to do an evidentiary hearing every time a consent decree comes through, because there's no way a court can review a consent decree and know the ins and outs of the consent decree without doing that.
Absolutely not. But the court has an obligation as the gatekeeper, especially when we have one side that's represented by attorney and not. The court has
So
an
you're saying in that scenario,
No.
the court needs to have an evidentiary hearing?
No, but the court has to have an evidentiary hearing if they look at it and they see that we are exchanging property for child support, because the court's supposed to enter child support according to the guidelines, and some
But this
deviation.
consent decree said it was a deviation. And that happens, I did do it for a little while.
I'm well aware of that.
And there are deviations all the time in those consent decrees.
And deviations for child support. What this was a property disposition in exchange for child support. There's no child support.
It's a deviation. It says it's more than enough it's a deviation, and there's more than enough in the 61-39 split to cover the difference.
But giving away property in perpetuity beyond the emancipation of the children, and actually for life, because he's obligated under this consent decree to leave in his will his separate property to her that's his family business.
They reached an agreement that the court could not impose absent an agreement. You're right.
And
does that mean it's unenforceable, though? What's your best case for the proposition
the court
that,
still has
if I could finish, that the parties can't agree to something that the law wouldn't otherwise provide?
They could, but it can't be something that is so inequitable and one-sided that once it's pointed out to the court, that's why we have Rule 85 and we have a 6-month limitation on it, because it could very well be, and I'm not suggesting that the court did anything wrong in the first instance of saying, I got a decree, both parties have signed it, and I'm going to enter it. Where the wrong part of it comes in is once it was pointed out to the court under Rule 85 that there were problems with this and that it's unfair and it's inequitable, because even the responding brief says, as long as it's fair and equitable, we don't really care what the parties came up with. Once the court knew that it was no longer fair and inequitable, forget about the incapacity.
Actually, the statute says it's unfair. But could... in any of this, do we know what the 61% represents on an annual basis?
Yes, it's about $10,000 a month.
Well, where is... Oh, go ahead.
And again...
Where would we get that from the record?
You wouldn't, because the record would have to indicate, because the record would have to have that evidentiary hearing where he says it was an unfair result. What we were expecting then is the court to hold...
Why didn't you put that in your Rule 85 motion? I mean, to me, that's... what would say, look, it's $10,000 a month. That's more than the $256 that we needed to deviate from.
And Your Honor, that's a very good question. However, I think there's, what we're asked to do in a lot of times in family court is provide enough notice to the other side to identify what those allegations are. And we provided that notice and allegations of this is unfair, it's unreasonable, you have a property, it's vastly in excess of what the child support amount should be. We didn't go through the specifics of attaching documents and evidence, but that's why you have an evidentiary hearing, so you can identify all those
You
things.
just told us it was $10,000 a month. How hard would it have been to make that notice
And I'm telling
allegation?
you roughly that's what it is, but those are facts that I have come to know now too. But those are facts that could have been placed in an evidentiary hearing before.
Isn't that fact that could have been placed in the Rule 85 motion?
But Mr. Murray shouldn't be punished for merely saying that it's inequitable, it was drastically different than the $236, that it identified property in exchange for child support, which we believe was improper. He made those allegations, and he didn't have to make all the evidentiary allegations. Once there was a response and wife contradicted that, then we believe the proper course would have been for the court to then set an evidentiary hearing. I see I have about 3 minutes left, and I'd like to reserve that time.
Thank you.
May it please the court, Thomas Morton for the petitioner appellee.
Counsel, let me jump in before you even start. Your client's position is that appellant didn't put enough in the Rule 85 motion to warrant an evidentiary hearing. Is that?
That's correct, Your Honor.
What would appellant have to have put in the Rule 85 motion to warrant an evidentiary hearing? What more than they did put in?
One thing, Your Honor, would be to actually allege incapacity or actually allege that he was under the influence, which he didn't do. He alleges misconduct on the part of my client, and you would have to actually allege misconduct. It's not enough just to say misconduct. The alleged misconduct is she knew he had a substance abuse problem, obviously not misconduct. Otherwise, anyone who ever entered into a consent decree with someone who they knew to have a substance abuse problem, and I would venture to guess that almost anyone who's married to someone knows whether or not they have a substance abuse problem unless they hide it really, really well. So anyone who ever enters into a consent decree with someone they know who has a substance abuse problem is committing misconduct. There's nothing to support that. Let's see, he alleged that she used high-pressure negotiation tactics. Well, negotiating isn't misconduct, and she never said what the high-pressure negotiation tactics were. If he said that, if he said, for example, something that would constitute duress, to extreme example, make him the offer he can't refuse, hold a gun to his head, well, sure, that's misconduct, but just saying, well, he negotiated really hard with me, that's not misconduct. And then the third one, the third allegation of misconduct was that she presented him something other than he'd agreed to. And she disputes that, but supposing that's true, he still signed it. He still averred to the court that he read it and it was not unfair and that he agreed to it. So that's not misconduct either. I mean, maybe if he was still on the 5-month bender and under the influence and couldn't read it, and she said, yeah, this is exactly what we agreed to, and he signed it, sure, that's misconduct. But just to say, hey, I've changed my position.
Does he need to know? Does he need to be on the bender? I guess my point is, if she presented him with a consent decree that was different than what he had agreed to, and he signed it because she represented to him that it was in fact what they had agreed to, and he said, okay, and he signed it because he trusted her. And then 2 months later, he realizes that, hey, this isn't what we agreed to. Isn't that misconduct?
It is arguably misconduct, Your Honor, but it's, if he had the chance to read it and understand it, it wouldn't be misconduct sufficient to throw out the decree.
Oh, really? Why? I don't, but...
Because he signed it and said that he read it and understood it and it wasn't unfair and he agreed to it.
Oh, he took her on her word. But do we have in this record what the agreement he believed they reached and how it differed from the agreement that he signed?
No, it's not in the record, Your Honor, and that goes to the point in the answering brief that we have bare allegations here. We don't have enough detail in the Rule 85 motion to warrant a hearing. He says, well, she gave me something other than what I agreed to. He doesn't say how it's different. It could have been different by one small insignificant term. It's really not misconduct for Mother to change her position and present him, he didn't allege it, but it could have very well been, hey, I've thought about it and I changed my mind and this is what I want you to sign now. That's not misconduct. Had Father presented more details, maybe he could have alleged something enough to warrant a hearing, but he didn't. He just said, she just gave me something different. And I had a substance abuse problem, and she knew I had a substance abuse problem. That's not misconduct.
See, I'll tell you where I'm struggling with, and that is the idea that she could give him a document, have him sign it, and that not be the agreement that they had reached. Now, I'm not saying that happened. I'm just saying that, to me, tricking somebody into signing a document is not entering into a contract.
Your Honor, he doesn't say that she tricked him into signing the agreement. And if she tricked him, I would agree that's misconduct. But what he alleges is she gave him something different, and he signed it anyway. He doesn't say she tricked me. He says she took advantage of me because I was vulnerable and because she knew I had a substance abuse problem. That's not tricking. That's even if it's true, she gave him something different and told him this is what I want now. He still signed it. He still signed it under oath that he had read it, he understood it, he agreed to it, and it wasn't unfair. Are there any other questions from the panel?
I have a question. Do you agree that it's a $10,000 payment of the 61% of the business?
No, Your Honor. There's nothing to support that in the record. This is the first time I've ever heard that the difference between 61% and 50% is $10,000, and that's certainly not what my client has been paid since the entry of the decree.
So the difference of what she's entitled to and the difference of what he's paying her is 11%?
Yes, Your Honor.
And there, I didn't see anything in going through this record that would indicate to me what that difference is.
The amount of the difference?
The amount of the
Yeah.
difference.
No, Your Honor. There's nothing in the record to indicate that.
And correct me if I'm wrong, but child support can be modified. So this is just income. I mean, once the property is settled, it's just income. So the day after the thing was signed, he could file a petition to modify.
Yes, Your Honor, if he could show that there is a significant continuing change in circumstances.
15% difference.
Fairly simplified process, Your Honor.
Yeah, sure. So if she's getting an extra amount of money and it's income, and he can show that, she's not entitled to, maybe he's entitled to child support. If she's getting a large chunk of change difference and she's already working, that could change the equation that would result in him receiving child support.
It could, Your Honor.
All right.
Is there anything else that the panel would like me to address?
No, thank you.
Thank you.
Counsel, you've got just a little less than 3 minutes for rebuttal.
Your Honors, I wanted to point out in the motion for relief some of the questions that you had asked about whether or not there was allegations with respect to it. On page 2 of our motion for relief, it specifically says that regrettably during the course of negotiations between the parties and on the date the parties signed the decree, husband struggled with issues pertaining to substance abuse. It goes on to say in paragraph 4 on page 2, again electronic record number 20, wife's actions culminated in her submitting a drastically different document for husband to sign than what the parties had negotiated. All of those are allegations that indicate that there was a different document that he was being asked to sign there that would necessitate an evidentiary hearing. And I just want to follow up on the child support modification thing because it doesn't really, if she's getting additional income from it and you try to then modify child support, that's not what this document did. This document talked about actually giving her away property in exchange for child support.
It's just income.
But the income with respect...
It's going to fluctuate over time. So 1 year it could be, I'm picking a number out of the air, but 1 year it could be a difference of $1,000, and next year it could be $5,000.
Yes, but Your Honor, the child support, though, is based not on, it could be based on her income, and then she changes it.
It's what she's working and what she's receiving from any other income source.
But it doesn't eliminate the problem that she has received a property equalization for what she thought was an exchange of property. How do you go back now and say, now give me back my property because you, the court, divided up my separate property and you did that in order to give her child support? And I think that's the major issue and problem, is that this decree provides for it's not your typical deviation of child support.
But but they do that all the time in spousal maintenance.
And again...
And make it non-modifiable and it's contingent upon the property division.
And that you can do for spousal maintenance, but this is not a spousal maintenance case. It was in lieu of child support, not spousal maintenance, because that might have been a better way for them to do that consent decree, is to say, I'm not getting that, but you're giving me this in exchange, and that's how I'm equalizing. It's more of an equitable distribution state than a community property state, but that might have been a different argument. That's not what occurred here. What occurred here was, I'm going to give you, beyond the age of majority, this increased income and this property, because I'm giving you shares in that property should I die. And that goes way beyond any child support in this case. This is not as a simple, you're getting additional income now and we're going to modify the child support. I see I'm out of time.
Thank you. Thank you, counsel, both for the written briefs and for argument today. We'll take the matter under advisement and issue a ruling in due course. We'll stand in recess while our next oral argument sets up. Thank you.